If you are watching this vlog, it is to come to your own opinion on the subject, in which case my opinion, because I do have one, is totally irrelevant. That said, Tommy Robinson's contempt broken down. Tommy Robinson's condemnation for contempt of court has been something that I've been following from the very beginning. It's fascinating and a little perplexing from a legal perspective. I've already done one video on the subject sort of explaining what contempt was. I'll link that video right here. For those of you who have already seen it, I may be going over some stuff that I talked about in that video, but it's necessary to have a full picture of what we're talking about now. Contempt of court is sort of the inherent power of the court to ensure that decorum is respected within the court and that court orders are respected outside of the court. And to that end, you have two types of contempt. You have contempt in facie and contempt ex facie. In facie literally means in the face of the judge. Ex facie means literally not in the face of the judge or outside of the face of the judge, outside of the courtroom. In facie contempt would include things like having your cell phone go off repeatedly in the courtroom, getting into a fight in the courtroom, swearing at the judge, attacking a bailiff. Ex facie contempt typically involves not respecting an order of the court. For example, in the case of an injunction that would order a counterfeiter to stop selling counterfeited merchandise, if that person continues to sell counterfeited merchandise, they would be committing contempt ex facie for violating an order of the court. Contempt, at least in Canada, are what we refer to as quasi-criminal proceedings. Quasi-criminal in the sense that in practice and in reality they do result in incarceration at times. They result in the physical deprivation of one's freedom, hence they are treated as quasi-criminal proceedings. And that means that the burden of proof in matters of contempt is beyond a reasonable doubt. To the extent that an individual runs the risk of physical imprisonment, the burden of proof is beyond a reasonable doubt. And in order for contempt to actually result in imprisonment, it has to be repeated, it has to be in your face, it has to be over the top egregious. In my previous video on the subject, I gave some examples of contempt that actually resulted in imprisonment, and it typically involved repeated and stubborn violations of an otherwise clear and concise court order. One field of law where contempt abounds, family law. When people get emotionally invested in divorce proceedings, they stop acting rationally and they get themselves into trouble. I'm going to get to one of those cases later. It's over the top. Okay, I'll get to it now. A man spent 14 years in prison for refusing or failing to disclose where his assets were in the context of a divorce so that his wife could have her fair share in the divorce. 14 years in prison. We'll come back to this later. Now, with all that said, let's bring this back to Tommy Robinson's situation. His real name is Stephen Yaxley-Lennon. His name will elicit reactions from both sides of the political spectrum. Some people will see Tommy Robinson as a truth seeker, others will see him as a political activist, and others will consider him a right-wing extremist. And this is what I mean when I say we have to separate the subject from the subject matter. The purpose of this vlog is to explain the contempt orders that were issued against Tommy Robinson, not to discuss, condone, or condemn any aspects of Tommy Robinson as an individual. And I suspect that there are going to be similar reactions to this vlog that there were to my previous vlog on whether or not Canada has freedom of speech, where I broke down the Mike Ward decision of a stand-up comic who was ordered to pay $42,000 by the Quebec Human Rights Tribunal to a 14-year-old kid and his mother for certain jokes that he made in one of his stand-up bits. People took issue with the laws that were in play in that particular judgment that allowed the Human Rights Tribunal to come to that decision. People took issue with the existence of a Human Rights Tribunal in the first place, and I can totally understand that. Again, the purpose of that vlog was neither to condemn nor to condone the laws that apply in Canada nor the tribunals that apply those laws. It was only to explain it so that the outside world could understand what actually happened in our province. The same holds true for the Tommy Robinson situation. Now, for anyone who has been living under a rock and doesn't know what's going on. In May 2017, Tommy Robinson was held in contempt of court for recording inside the courthouse during a trial for which there had been a publication ban. Now, from what I understand, Tommy Robinson was not recording in the actual courtroom, but rather only in the courthouse. So Tommy Robinson's first condemnation of contempt of court was for filming inside a courthouse in the context of a trial in respect of which a judge had already placed a publication ban under UK law. And this is something that needs to be fleshed out. Publication bans. Publication bans exist pretty much in every jurisdiction in one form or another, and it's the inherent power of the court to order that certain details or facts or names of witnesses not be disclosed by the press to the public in order to ensure a fair trial for the defendant, in order to protect the privacy and ensure the safety of the victims or the witnesses. In the US, they're often referred to as gag orders. In Canada, it's actually codified under certain provisions of the Canadian Criminal Code, as relates to not releasing the names of witnesses, victims, especially if they're minors, victims of certain types of crimes. Section 517 of the Canadian Criminal Code authorizes a judge to order publication bans for bail hearings, as relates to certain matters of especially high-profile criminal trials. And the Supreme Court of Canada has adjudicated on how one reconciles the freedom of the press with these restrictions that judges can sometimes place on the freedom of press, freedom of expression, free dissemination of information. But these gag orders, publication bans exist in the US to some extent, in Canada, and they exist in the UK. Now, the publication bans at issue in the context of Tommy Robinson's contempt were apparently issued under Section 4.2 of the Contempt of Court Act of 1981. And that section reads as follows. Contemporary reports of proceedings. Subject to this section, a person is not guilty of contempt of court under the strict liability rule in respect of a fair and accurate report of legal proceedings held in public, published contemporaneously and in good faith. In any such proceedings, the court may, where it appears to be necessary for avoiding a substantial risk of prejudice to the administration of justice in those proceedings, or in any other proceedings pending or imminent, order that the publication of any report of the proceedings or any part of the proceedings be postponed for such period as the court thinks necessary for that purpose. Whether you agree or disagree with the law, whether you agree or disagree with the discretionary power that it gives to a judge, whether or not you feel that it is totally diametrically opposed to a free society, freedom of speech, freedom of the press, whether or not judges exercise this discretionary power too frequently, arbitrarily, in a political manner, that is a matter of opinion. The purpose of this vlog is only to explain the law, and that is the law. So in 2017, Tommy Robinson was found guilty of contempt for violating an order of the court under Section 4.2 of the Contempt of Court Act. He was sentenced to 3 months in prison, but was given a suspended sentence, meaning that he did not actually have to go to jail, but would go to jail for that sentence if he committed another act of contempt. And whether or not a condemnation of 3 months in prison, even if suspended, was excessive or unreasonable under the situation, that is a question of opinion. Like I always say, when you leave something in the hands of a judge, you can never predict the outcome. Fast forward a year, Tommy Robinson is doing a Facebook Live outside of the courthouse in the context of another trial for which there has also been a publication ban under Section 4.2 of the Contempt of Court Act. Tommy Robinson is filming on public property, by all accounts is reporting stuff that has already been reported and is therefore in the public domain, but at one point during the Facebook live stream interacts with the defendants. Now at this point in time, the trial had come to an end, but a verdict had not yet been rendered by the jury. Tommy Robinson gets arrested for disorderly conduct or disturbance of the peace, not actually for the contempt, and while in custody, the judge discovers that Tommy Robinson was live streaming outside the courthouse and decides to pursue contempt proceedings. And within a period of 5 hours, arrests Tommy Robinson on contempt proceedings, charges him, tries him, and sentences him to 13 months in prison within a 5-hour time frame. Not only does the judge do all of this within a period of 5 hours, but the judge also orders a publication ban, also under Section 4.2 of the Contempt of Court Act, prohibiting reporting on Tommy Robinson's arrest, condemnation, and sentencing to 13 months in prison. Now, one does not even have to have the slightest inkling to like anything about Tommy Robinson to appreciate that there's something potentially procedurally improper about what just transpired. You don't have to be a Tommy Robinson lover to have recognized that there was a procedural injustice in the whole procedure, and it's not because you hate him that you shouldn't care. You should care about procedural injustices regardless of whether or not the subject is someone you love or hate. An injustice today for someone you hate may be an injustice tomorrow for someone you love. Write that down. And after about 4 months in prison under this arrest, trial, condemnation, and sentencing within a 5-hour period, Tommy Robinson's appeal of that process and judgment was in fact granted. The court came to the conclusion that there was a certain fundamental procedural unfairness that allowed for the arrest, trial, conviction, and sentencing to 13 months in prison within a 5-hour time frame. Now, the theoretical justification as to why the court proceeded so quickly with the arrest, condemnation, and sentencing of Tommy Robinson was to ensure that the criminal trial that was ongoing was not going to be prejudiced by Tommy Robinson's alleged act of contempt. That was at least the theoretical legal justification for why the court acted the way it did. And the court that overturned the original contempt condemnation wrote as follows. Even in cases where a court considers it necessary to proceed summarily to deal with a contempt, it is often wise, having sorted out the immediate concern, to adjourn the contempt hearing to a later date and sometimes before a different judge. That avoids any questions of the judge being judged in his own cause. In most cases concerning an interference with the public course of justice, the judge will refer the matter to the Attorney General. And the court proceeded to quash the original contempt order for the following reasons. In summary, the finding of contempt made in Leeds must be quashed because it was inappropriate to proceed immediately on the motion of the court to deal with the alleged contempt after immediate steps had been taken to remove the offending video from the internet. An adjournment was necessary to enable the matter to proceed on a fully informed basis. In any event, the failure to comply with Part 48 of the rules resulted in there being no clear statement, orally or in writing, of the conduct said to compromise a contempt for contravening the Section 4.2 order in place. It was unclear what conduct was said to comprise a breach of that order, and the appellant was sentenced on the basis of conduct which fell outside the scope of that order. The haste with which the contempt proceedings were conducted led to an inability of counsel to mitigate fully on the appellant's behalf. So the condemnation of contempt, for which Tommy Robinson was sentenced to 13 months in prison, 3 months for the suspended sentence, and 10 months for the new act of contempt, was quashed, and a new hearing on that contempt was set. And a lot of people were saying that this constitutes something of a double jeopardy, Tommy Robinson being retried for the act of contempt that he was tried for a while back. The main difference, however, being that Tommy Robinson wasn't acquitted and being retried for an accusation for which he was already acquitted. He was found guilty, but that condemnation was overturned and a rehearing was ordered. And Tommy Robinson's lawyers argued that to the extent that he had already served 4 months in prison, the matter should not be retried. And even though the court quashed the original condemnation, they did conclude that on a rehearing, it is possible that Tommy Robinson could be sentenced to even more than time already served. Tommy Robinson could ultimately be sentenced to more than the 13 months because under UK law, the maximum sentence for contempt of court is 24 months in prison. And Tommy Robinson was again tried for contempt of court for filming outside of a courthouse and allegedly violating Section 4.2 of the Contempt of Court Act and the publication ban on that ongoing trial, and he was again found guilty but has not yet been sentenced. It's going to be very interesting from a legal perspective to see what happens on the sentencing, because let's just say, for example, he's sentenced to 4 months in prison. In theory, he doesn't serve another 4 months because he has already served 4 months. If the court comes to the conclusion that notwithstanding the contempt, no imprisonment was justified, but rather only a fine, well, the court has effectively taken 4 months of Tommy Robinson's life. On the other hand, if the court comes to the conclusion that the contempt was so egregious and so over the top that Tommy Robinson should serve a full 24 months maximum sentence in prison, well then in theory Tommy Robinson has another 20 months to serve given that he already served 4 months. And that is the Tommy Robinson situation. Agree or disagree with the law, that is the law. Agree or disagree with the application of the law, that is nonetheless what happened in this case. Whether or not you think it's politically motivated, whether or not you think it's retribution for what Tommy Robinson has done and said on the side, that is a question of opinion and perspective. We all have our own, but at the very least, now you know the facts, now you know your vlog. If you like this content, be sure to like, share, subscribe, hit the notification bell. If you have any recommendations, suggestions, constructive criticism, drop it in the comment section below. And now you know your vlog. Peace out. Boom!